Did you know that most grievances investigated by the Office of Lawyer Regulation, or OLR, in Wisconsin relate to fee disputes? As part of the investigation process, your fee agreement and trust account records may be requested. I'm Christopher Shattuck, the State Bar of Wisconsin's Law Practice Assistance Manager, and today I'm joined by Travis Stieren, Trust Account Program Administrator for the Office of Lawyer Regulation. Today we will explore and address some of the common trust account violations. Travis, thank you for joining us.
Thanks, Chris. I'm happy to be here.
So Travis, what is the most common trust account violation?
The one that we see most often is lack of fund availability in the trust account. There's simply not enough money in the trust account to cover whatever check has been presented.
And does that just relates to attorneys overdrafting their trust account because they think more money is in their trust account than what actually occurs, and then they might have an extra charge or fee that hits their account and they're not aware of that?
That's right, yes. We see fund availability issues where they don't have enough funds to cover a check. At the outset, when people open their trust account, very often they don't deposit some funds in there. And then they get hit with a check printing fee or some other bank fee right away, and we get an overdraft right at the outset of them opening the trust account. The other really common fundability issue is just not being aware of the bank's fund availability policy. And that is, they get a settlement check in, the client wants their portion of the proceeds, the attorney deposits it, and then waits even a day or two and disperses it to the client, but the funds actually haven't cleared yet. Even though the attorney may have held on to it for a little while and thought that was long enough, you need to make sure the funds are actually through the account and have cleared. The best way to do that is to get a written copy of your bank's fund availability policy, and also to check the account before you disperse a proceeds check to a client or a third party, especially when there's large sums of money. I would say 5 figures or greater. The banks are putting longer holds on funds, and in particular cashier's checks. So you're going to want to make sure the funds have cleared. And if a large check, I would pick up the phone and call my banker and make sure it's through. Otherwise, the funds may not be yet available. And when your proceeds check hits the trust account, you can get an overdraft.
And it sounds like with those maintenance account fees, and in looking at the Office of Lawyer Regulations Trust Account Manual, that there is a reasonable fee amount that a lawyer may deposit to cover those maintenance fees each month, but they're not allowed to put in an exorbitant amount of money just to cover any overdrafts due to their own error or oversights.
That's right. We call it a maintenance account. We recommend law firms put in about $100 of firm funds in the trust account just to cover unexpected bank fees and charges. And the rule does allow for that. It's basically a nominal amount. You do need to keep track of that with your trust account records. It could be larger than $100 if it's a very busy law firm, but we find that that usually covers it, covers any monthly fees or check printing charges.
And I know another issue that commonly comes up is that lawyers fail to keep contemporaneous trust account records because they assume either their bank will be keeping the necessary records that they need to keep, or that their practice management software will take care of that sort of automation for them. What's your quick advice for attorneys to make sure that they're keeping contemporaneous records?
Well, the rule is, puts the onus on the attorney to keep contemporaneous records. And while we have no particular at this time requirements with respect to which particular records are to be kept, we do recommend that you keep a running transaction register and a subsidiary client ledgers. And then, of course, you are required to keep your canceled checks or your images of your canceled checks and any and all deposit items. And so these are records that the bank may not be aware that you need to, and they may not even be able to create it on their own. And as well, your third-party software is not going to be able to create all of the records that you need without you setting it up, and also without you obtaining the necessary documents, the deposit items and the checks from the bank. So there's a number of things that you need to do to ensure that you have everything to present to OLR if we are investigating one of an overdraft or another matter with your trust account.
So as a best practice, attorneys should take a look at the OLR's guidance for record keeping on the Office of Lawyer Regulations Trust Account page and make sure that they're making copies of their records each month.
That's right. Yes, we have guidance up on our website, and like you said, you want to have a paper copy of your records each month. And we recommend, if you're keeping electronic records, you also have them on a separate hard drive backed up somewhere off-site in case there's any problems.
Okay, so outside of the record keeping guidelines or the fund availability, I get a lot of calls and questions from folks dealing with electronic payments into trust accounts. So these are payments that lawyers are required to keep into trust accounts. What's some of the common issues you see on your side, Travis?
Well, we get these questions a lot. Obviously, more and more of the banking industry is going to electronic transactions, and we get a lot of new attorneys saying, I got calls last week about people wanting to take and accept electronic payments, and are those allowable under the rule? And unfortunately, under the standard trust account rule, you're not allowed to have third-party electronic payments in or out of your trust account. Attorneys can make remote deposits of checks into their trust account, usually using a bank scanner they'll provide for you, but that's pretty much it. Otherwise, no ACH transactions, no credit cards, no PayPal, none of that under the standard trust account rule. If you want to, but the court has now allowed, since 2016, a broader uh, uh, range of options for electronic payments. And one of which is to set up a separate e-banking trust account, which is a second trust account that you maintain for the purpose only of accepting electronic payments and making electronic payments. So that's one option you have, is to have two trust accounts, one an e-banking trust account. The second option is to set up what we call an all-in-one trust account. This is an exception under the rule in which you can use your standard IOLTA trust account for electronic payments and disbursements and deposits. But you need to comply with a number of additional security measures. Most notably is a crime insurance policy or bond that covers fraud in the trust account.
And a great overview of this is the options for trust account management brochure that goes over and covers these different types of transactions. Another issue that I commonly see that comes up, Travis, is commingling funds into a business account. That is, an attorney receives an advance fee, and they're also, as part of that payment, receive an advance cost. And if their advance fee is $2,000 and they receive $5 in advance cost, and that payment comes in the form of one single check or transaction, attorneys are required to first place that money into the appropriate trust account and then disperse it appropriately according to their different fee agreements. Is this something that you commonly see as well, the commingling issue?
Yeah, it's that comes up quite a bit. Attorneys, as you said, will oftentimes they'll get a mixed check that's a client paying for a portion of a fee that's already been earned for some services you've already provided, plus they're giving you an advance on some future work. And what you need to do with those kinds of funds is because the rule 20:1.15b1 is the very first thing, is you can't commingle third-party funds with the attorney's own funds, is you need to take those funds, a mixed check, you put it into the trust account, and then once the check is cleared, you can then cut a check to yourself for your fees that have already been earned, and then deposit that to your operating account. So the way you want to do it is, if there's mixed funds that should go in the trust account and then funds that you are entitled to, you need to first deposit it to the trust account and then disperse the funds to yourself in short order.
And I made reference earlier to fees, and I'm glad that you clarified advanced fees versus earned fees. So let's talk about advanced fees. So if an attorney agrees to enter into a flat fee with someone to do criminal representation through a certain stage of a hearing, and the attorney is not using the alternative protection for advanced fee language and abiding by those rules, an attorney who receives an advanced flat fee, what must they do with that money?
Um, under the fee rule 20:1.5 sub F, a flat fee must be held in trust, just like any other advanced fee. Even if the attorney says, regardless of the language that's in the fee agreement, The court looks at the reasonableness of fees, and the fees must always be earned before they can be considered truly the property of the attorney. So flat fees are another type of advanced fee, just like an hourly fee. They do need to be placed into the trust account until such times you've earned them, and then they can be withdrawn. And the way you figure out if a flat fee is earned is to define in the fee agreement, what particular services, what portion of the fees for which part of the service that you have done.
And again, the OLR's trust account manual contains a great resource explaining this and also discussing the provisions of the alternative protection for advanced fee language, which I referenced earlier. So Travis, I think we're all on the same page here that, attorneys should take a look at the Office of Lawyer Regulation trust account program page with all the materials that are there. They're also encouraged to attend continuing legal education seminars offered by the State Bar of Wisconsin. I know the Office of Lawyer Regulation also biannually hosts this seminar on these types of topics. Any other advice you have for attorneys?
Yeah, we actually, our seminar right now is just once a year, for the time being, but it's going to be in September. We do this, we've considered it to be kind of trust account 101. It's a half day, and it gives you everything you need to know to open, start, and operate your trust account. And it's CLE approved as well. It's a great opportunity for CLE if you need those. Any other advice I would have is to keep abreast of what the rules are. The court has looked at this, and especially with the way the banking industry is changing, they're constantly looking to update it and to make it a little bit more manageable for attorneys. So I would keep abreast of any changes in the rule and to look to our website for any guidance, because there's a lot there.
And of course, if any members of the State Bar of Wisconsin need any guidance on this, they can contact the State Bar of Wisconsin's ethics program for confidential consultation. If they have any practical questions, they can also contact my program. And I know, Travis, you are willing to entertain prospective questions from attorneys, not questions after they've already completed some sort of action and then call your office. So we'll make sure to include those contact informations in the follow-up article. And Travis, I want to thank you for your time today and appreciate you sharing your knowledge with us.
Oh, no problem. Thanks, Chris. I appreciate it.
Thank you.